If we are heading now to Las Vegas, where the man who assaulted a judge made another court appearance this morning, this time answering for that attack. You've seen the video. It went viral last week, showing Deobra Redden vaulting over the bench of Judge Mary Kay Holthus and then attacking her while she was sentencing him. It took several people to subdue the flying felon, and he's now facing 15 new charges. But before we bring in our guests, let's listen back to some of that hearing that got underway earlier today.
Hello, are you Mr. Redden?
Yes, I am.
Hello. Okay, I have a few housekeeping matters to handle before we handle his case. In anticipation of me appointing the public defender to represent him, there are multiple media requests. There were multiple orders that were signed in initial appearance court. I have amended several media orders to not allow live streaming because I do not allow live streaming. So to the extent initial appearance court allowed live streaming, I have amended all of those orders to remove that. I have filed amended orders yesterday. There are some new orders that I need to rule on, one from KLAS, one from Univision, one from Associated Press, and one from Fox 5. Does the state have any opposition to these media requests?
Your Honor, I'll submit it to the
Does the defense?
I'll submit it to the court.
Okay, I'm going to sign and approve these media requests. They are not for live streaming, and they are only for any sort of media that the media requested. All right, as for disclosures, before I arraign Mr. Redden, I want to disclose under Judicial Canon 2.11, Comment 5, that I do know Judge Mary Kay Holthus. I know her very casually and only professionally. I've never socialized with her outside, say, a professional event. I do, for instance, not know her phone number. I don't think she knows mine. We're not connected on social media. I've never worked at the district attorney's office, where I believe she worked for her entire career. Her daughter is a deputy district attorney on my track. However, the team chief has assured me that Kennedy Holthus will not appear on any of Mr. Redden's appearances. Therefore, I see no reason to recuse. However, I make those disclosures under Rule 2.11, Comment 5. Mr. Redden, have you been given a copy of the criminal complaint this morning?
Yes, I have been given one.
You're being charged with count 1, attempt murder, victim 60 years of age or older, a felony. Count 2, battery on a protected person resulting in substantial bodily harm, victim 60 years of age or older, a felony. Count 3, extortion by threat, a felony. Count 4, intimidating a public officer, a felony. Count 5, 6, 7, 8, and 9 are all battery on an officer, the same name victim. Oh, and by the way, I do not know any of the other victims named in the criminal complaint. Those are all felony offenses. Count 10, performance of act or neglect of duty and willful or wanton disregard of safety or persons of property resulting in substantial bodily harm or death, a felony. Battery on a protected person, count 11, that's a gross misdemeanor offense. Count 12, battery by a prisoner, a felony. Count 13, unlawful act related to human excrement or bodily fluid, a felony. All allegedly occurring on January 3rd of 2024. Do you understand these charges?
Yes, I understand.
Can you afford to hire a private lawyer at this time? I'm sorry?
I'm trying to,
Can you afford to hire a private lawyer of your own expense and choosing?
no, not at this time, no.
Are you a veteran or a member of our military?
No.
I can appoint a lawyer from the Public Defender's Office to represent you.
Thank you, Your Honor. And prior to Your Honor calling the case, I did, as a friend of the court, talk to Mr. Redden about his right to a Valdez-Jimenez hearing. I know that he did not have one in initial appearance court. However, he's going to be choosing to waive the prompt hearing given the circumstances that happened yesterday in district court where he's already been sentenced in his other case.
Okay, so he was sentenced?
Correct.
Okay, was he sentenced to jail or prison?
Correct.
Okay.
19 and 48.
Okay.
So he understood that and said that he's not trying to have the hearing today.
Okay, that's fine, and I'll canvass them on that. My only issue is I think what has happened is some standard bail figures have carried over since booking. So by the time he sees a judge, he is entitled to a Valdez-Jimenez hearing, but it is at that point that the court sets release conditions. So I'm removing the standard bail numbers that were only assessed at booking, frankly, until he sees a judge. And given the attempt murder charge of count 1, that is a set in court bail. So the standard bail numbers will be removed. It will be replaced with a set in court bail or release condition. He is entitled to a Valdez-Jimenez hearing within 48 hours unless good cause shown. But you say, Mr. Redden, Ms. Medina tells me that without waiving a bail hearing completely, you're at least willing to waive it for now because you have some other issues you have to handle. Do you understand and agree with this?
Yes, and I'm going to waive.
Okay. All right. So he'll just be on a set in court bail unless further ordered by the court. We need to set his preliminary hearing. Would you like that set within 15 days?
He's going to also waive the 15-day set and we'll do 30 days.
Okay. Sir, you have a right to a preliminary hearing within 15 days, and Ms. Medina has said that she's talked with you about that, and you're willing to give up that 15-day period and instead set your preliminary hearing within about 30 days. Is that okay?
Yes, that's fine.
Is this okay with the state?
Yes, Your Honor.
Okay. Does the state? Yes?
After we get the date, can we approach?
Sure. Is there anything else, Ms. Mercer, you want to address?
No, Your Honor.
Okay. All right. Here's a 30-day preliminary hearing date, unless I see you earlier, and if you'd like to approach, you may.
February 14th at 9 a.m.
Completely different scene inside of that courtroom than we saw before. Just the distance between the defendant and the judge. Let's bring in our guest standing by for this hour. First, someone with a personal connection to the Las Vegas courtroom here in studio. Crime and Justice correspondent Matt Johnson is with us. And also standing by remotely is Wendy Patrick, trial attorney and prosecutor, also weighing in. First, Matt, let me start with you. When you see everything that's unfolded in this case, what are your thoughts having been there on the ground, a journalist in Las Vegas?
Shock, like everybody else. But here is why also, you and I cover courtrooms all across the country. And this particular courthouse, they have extra security. And I'm talking, when I was a reporter there, I covered a little known case of O.J. Simpson during the armed robbery case. That was back in 2008. So at that time, when I'm thinking back, it was not just one set of security, but two that you went through, including the media. So that comes to mind, and also the setting of where this courthouse is located. So this is located in the downtown Las Vegas area. That's the Fremont. You think of, the Rat Pack and all of that, the hotels that were imploded. This is in that downtown area. There's a lot of crime in that area. There's also a lot of not only tourists, but homeless population. So they really do have added security here. And what I've noticed in this video that you actually talked about today was the fact that he was kept so far back. And there was something like 6 Clark County Sheriff's deputies surrounding him. He still had the mitts on. He didn't have the spit mask
today.
He had like just a regular mask, but they were not letting him anywhere near that judge today.
Extra abundance of caution. Wendy Patrick, let me ask you about this attempted murder charge. Not saying it's not warranted in this case, but that's a heavy level when it comes to the options that a prosecutor has in charging someone who's accused of what we all saw unfold on that screen.
And because, Julia and Matt, we all saw it unfold, we can understand the rationale behind a charge like that. Think about any other type of case when you didn't have a judge being the victim. You would look at things like demeanor. How do you prove intent? All the different circumstantial elements that would lead you to believe it was an intent to batter versus an intent to kill. You talk about him being a flying felon. The force with which he leapt across that bench, the rage with which he fought with the people in the courtroom, the deputies that were trying to control him, the fact that the one deputy had to go to the hospital, all of that factors into the decision of a charge to bring. This isn't somebody that threw something at a judge, or it wasn't a push or a punch. So when you look at all of that together, and like we always say, a picture may be worth 1,000 words, but a video is priceless in establishing some of those foundational elements And the prosecution felt that it fit here, and sure enough, that was the charge. That was actually the charge many of us felt would be coming, given the scene that we saw unfold in that courtroom.
So no battery, no assault, none of those things that he had been previously charged and convicted with. This is a much heavier charge that he is going to be now having to face. You described that video so well. Let's listen back to that moment that so many people have seen, but this leap and this attack on the judge.
Any other issues that may arise from the events that occurred last Wednesday will be handled at a future date by a different court. For purposes of the record, I want to make it clear that I am not changing or modifying the sentence I was in the process of imposing last week before I was interrupted by defendant's actions. In accordance with the laws of the state of Nevada, this court does now sentence you, in addition to the $25 administrative assessment fee, $150 DNA fee, the $3 DNA administrative assessment fee, and $250 indigent defense fee, 19 to 48 months in the Nevada Department of Corrections.
All right, that was post-attack. That was how he was subdued after the fact. And Matt, I wanted to get your sense of the difference between these courtrooms. Do you see any difference between not only the courtroom that was where this proceeding was for the attack, but also where the new judge was handling his case over this attack?
Right. So what a lot of the viewers might not realize is that there are different sizes of courtrooms in any particular courthouse across the country. So the first one that we saw with the honorable judge there that was attacked, and then we just showed the video of him with the spit mask and the mitts, that appears to be one of the smaller courtrooms. So he would have had shorter distance to be able to run and attack her. Versus the courtroom that we saw today, which looked like a much bigger courtroom. You could even see in the area where there may be a jury box that there was other defendants that were waiting for their cases on the docket. They were watching these 6 Clark County Sheriff's deputies bring him in and out as they were waiting for their cases. So that room, much bigger than the room that that judge was attacked.
There are also people speaking out on behalf of Redden, and that's his mother and his sister. Yes. I want to play some of that sound so we can get an understanding of what may be something that comes up through his defense.
Tell us about your brother and the brother that we haven't seen. You know, who is he like? What is he like? And how did he get in this situation?
Well, he's basically born with mental illness. He was born with crack cocaine in his system. So his chance in life was taken at birth. Deep inside, he's a good person. He's just not had the opportunity in life to be surrounded by positive people.
Do you think that this will, essentially him being sentenced, will undo all the work that he's done to repair his mental state?
No, definitely not. It's only going to put him in a worse state of mind because the system has failed him, and that's how he feels. That's how he feels that since the system fails him, so he's going to come out with that mentality and go forward in life, knowing that he has pleaded everything that he can, and being in a better place is different for us all. If he can be in a better place for a month, 30 days, for him, that's a lot.
Wendy Patrick, you're still with us. Your reaction to the family's reaction to this sentencing and this trial, but also the question about whether or not a lot of people have had he'll get better help behind bars than he would have as a free person.
You know, it's always awkward talking to family members who love the perpetrator, who love the defendant. And it's awkward for the family members to try to find something to say that doesn't downplay the seriousness of the crime, but also maybe is said with a sort of an edge towards looking for ways in which somebody can be rehabilitated. I've practiced law long enough to know that not everybody can be rehabilitated. But having said that, it doesn't mean we don't try. But in a case like this, the options are severely limited. They have to look at the seriousness of the crime, the potential for future violence, all of the kinds of threat assessment and management skills that would have, and probably in retrospect, should have gone into deciding whether or not this smaller room should to say, Julia and Matt, this case demonstrates, it's a chapter of one of my books in Red Flags, how familiarity breeds contentment. In other words, Matt is all about why that area of town is dangerous, yet sometimes if somebody is in the same environment every day, i.e. a small courtroom sentencing people that have been convicted of serious crimes, our guard goes down. We're not as situationally aware as we should be. So sometimes people miss the potential for somebody to literally fly off the handle like this, but that's going to go into deciding not only the charges, you heard it here, attempted murder, but the sentencing options at the back end of this case.
We will continue to watch that. Love getting your insight on these cases.